Ready for the dictation? Start. The respondent had taken some loan from the appellant Punjab Financial Corporation (start) hereinafter referred to as the corporation close for their business stop. It is not in dispute that the respondent failed to repay the loan in terms of the loan agreement and thus become a defaulter stop. The matter was accordingly settled in terms of one-time settlement policy of the appellant corporation on 1/4/2003 stop. It is also not in dispute that while settling the dispute by the order of the High Court dated 27/4/2006, the matter was referred to the Chartered Accountant Devinder to determine the remaining outstanding balance amount payable by the respondent against their loan amount to the appellant corporation and submit a report stop. It is annexure P5 stop stanza. Since the dispute arose even after settlement between the parties as to what is the actual and precise liability determined and was eventually worked out between the parties in the settlement and against the determined liability, how much amount the respondent has paid the appellant as per their calculation, raised a demand of rupees 49 lakhs start annexure P11 to the writ petition close on the respondent and called upon them to pay the said amount stop. The respondent, however, denied their liability stop. It is this demand which gave rise to filing of the writ petition by the respondent in the High Court against the appellant, out of which these three appeals arise and sought its quashing stop. The appellant contested the writ petition stop stanza. The High Court, by impugned order dated 1/8/2013, allowed the writ petition, holding that since the parties had consented to the settlement and pursuant thereto the entire exercise was carried out for working out the liability, the appellant was not justified in raising the demand in question on the respondent stop stanza. The appellant felt aggrieved and filed an application for review of the order dated 1/8/2013, but the same was also dismissed by order 14/11/2014 on the ground that since the appellant corporation did not raise any objection before the appointed chartered accountant and nor to the respondent, and hence at such belated stage, therefore they are not permitted to raise any objection on such question and nor to raise any demand stop stanza. It is against these two orders the appellant corporation felt aggrieved and filed the present appeals by way of special leave in this court stop stanza. The questions which arise for consideration in these appeals are whether the High Court was justified in allowing the respondent's writ petition and was in consequence justified in quashing the demand bracket start annexure P11 to the writ petition bracket close raised by the appellant on the respondent, and second, whether the High Court was justified in dismissing the application for review filed by the appellant against the order allowing the respondent's writ petition stop stanza heard learned counsel for the parties stop stanza having heard the learned counsel for the parties and on perusal of the record of the case we are inclined to allow the appeals and remand the case to the High Court for deciding the writ petition afresh on merits in accordance with law stop.